I'm Dr. Barry, licensed psychologist, and here we talk about true crime and psychology. Thank you so much for joining. Let's hop right into today's topic. Let's go. Thank you all for joining. Today, I am going to be covering some testimony in the Abby Zwerner civil case. And I also have I think it's a grand jury indictment. Let me see, because it's notes from the grand jury. Yes, the special grand jury report from an investigation from the incident that was on January 6, 2023. If you know nothing about this case happened right in my state of Virginia. I am a Virginia area psychologist. Please know, I could never talk publicly about a case that I was personally involved with. And so I do not know any of the I know none of the people involved. And with this one, I do know what Virginia schools are supposed to do. My child is an elementary school student in a Virginia public school, and there are policies and procedures that are supposed to happen. Abby Zwerner was a first grade teacher, and I believe this incident happened. I think she was 25 when the incident happened, and she is understandably unable to teach. The student involved, they just used the initials JT. This student was incredibly troubled. And the report of this student possibly having a dangerous item should have risen to top priority. And you would expect the administration to do something. And it's my understanding, based on the testimony that was given, that the assistant principal, she was focused on being a proctor for testing. Like, she was focused on doing the testing that they had for that day. And she never left her office. She never went and talked to the student. She didn't go to the classroom. She didn't call the school resource officer or the police to come to the school to investigate. The teachers and staff, everybody seemed concerned about this incident. And in a lot of schools, the admin, they are looked to as the ones that make the decision on what do we do next. And I honestly think that she thought there was no way that child had a dangerous item. Unfortunately, he did. And it's my understanding that after the first shot went off, he tried to pull the trigger again and the gun jammed. You all have done a phenomenal job providing updates in the comments. If you would like legal commentary on this case, JD Lawyer Explains, he is covering this case, and I'm super proud to announce. So I'm going to have Josh Ritter on my channel on Saturday. So please stay tuned for notifications for that one. Josh and I, he is an LA-based attorney. He's an attorney out in California. I'm going to have him on the channel to talk about this case on Saturday. Should be about 4 p.m. Eastern. Stay tuned for those notifications. I'll probably be scheduling that one in the next few days. But let's hop into the grand jury information, because that information not go to because there were some things that were left out of the trial and I think are out of the civil complaint. There's some things that were not allowed into the civil complaint. And after seeing the taking care of Maya, that judgment get overturned, and now they're going to have to try that case all over again. You kind of understand why judges sometimes rule to keep some out, to let something in that could be an issue on appeal later. And so remember, I'm a psychologist, I'm not a lawyer. But I did just want to highlight some things from the grand jury report. I have a link to the grand jury report down in the description. It was listed on Wavy 10, so that's a local news station. They had it right in the article, okay? And so there was an 11-member grand jury that met to address the question of was any action or decision taken that would have prevented the events that occurred on January 6, 2023? They made practical recommendations for improvement, and then also to determine if any of the parties in the Newport News Public School System administration should be criminally liable for their actions or lack of actions on January 6, 2023. I do want to note, so Dr. Parker, the school administrator at the time, she is facing these criminal charges. And the jury is not going to be aware that she has criminal charges as well. Okay. So I'm not going to do the overview, but I do want to go back to the 2021-2022 school year, because during that school year, JT was in kindergarten, and he exhibited a lot of behavior problems. He was in class, was Miss White, and he would get into other kids' faces. He was physically aggressive. He would kick and spit on other students and staff. And people in the administration, including Dr. Parker, were aware of these incidents. He also bragged about having access to his mother's, let's call it a tree plant. I can't say some words on YouTube, especially this early in the video. So I hope y'all know when I'm talking about what he had access to, located in her purse, and getting high off of it, which prompted a report to Child Protective Services. And so that's included in the grand jury report. On September, and just because something is released in the grand jury does not mean that all of that information will come into trial. Remember, I'm not a lawyer. We're just here to talk about these things here on YouTube. All right. So on September 27th, 2021. So in Newport News schools, I believe they start after Labor Day. I'm almost positive Newport News, if it's not after Labor Day, it's like late August. So within the first month, or in the second month of school, September 27th, 2021, Miss White was concluding breakfast with the other students when JT went to dump his breakfast in the hallway trash can and never returned. Miss White went to search for him and found him with the security guard. So he eloped. He left. Like, he went to throw away his trash and then didn't return back to the cafeteria. When Miss White tried to take his hand and bring him back to the class, the child hit her and yelled, "No, I don't want to go back to class." The child then aggressively twisted and pulled down the security guard's wrist. Due to his behavior, the security guard took the child to Dr. Parker while Miss White returned. Subsequently, a counselor returned to the class with the child and told him to sit down. At some point, Miss White was sitting in a kid's chair teaching class, and JT walked up behind her, placed his forearm in front of her neck, and pulled down so hard that she could not breathe. The teacher's assistant saw Miss White being, I can't say that word on YouTube, by the child, and rescued her by pulling the child's arm off and removing him from class. After only a couple of hours, the receptionist returned the child to class. Good God. And I think because it's a kindergarten student, but like, wow, like this student is exhibiting, and okay. Understandably shocked, Miss White stepped out of the class and told her that the child had no business being back in class. Agreed. Agreed. The receptionist responded that the child was brought back because there was no administrator available to deal with the situation. Miss White's teacher's assistant took over the class while Miss White went to get and fill out an incident referral form. She brought the incident referral form to Dr. Parker and Dr. Goodman. I believe Dr. Goodman used to be the principal. She also kept a copy for herself. She explained what happened, to which Dr. Parker did not respond at all, and Dr. Goodman responded by saying, "Prioritize." Wow. So she explained what happened, and Dr. Parker didn't say anything, and the principal said prioritize. Okay. While the school counselors and SROs were frequently involved in assisting Miss White with the child's behavior previous to this incident, so this was in kindergarten, no functional behavior assessment, FBA, or behavior intervention plan, BIP, was initiated either prior to this incident or after. Ooh. Administration instead decided that the child would be sent back to preschool and attend a different school. However, there was a subsequent clear lack of communication of that plan when the child returned the next day and was sitting in Miss White's class eating his breakfast. Miss White immediately went to see Dr. Parker about it and told Dr. Parker that either she, Miss White, would leave or the child, but they would not be able to be in the same class together. I mean, this child, like, yeah, yeah. After this ultimatum, the child was removed and sent to a different school. Okay. So, oh my gosh, I'm coming back to the chat. Like this is very, very concerning behavior. But this level of behavior would make me think what's happening. Like that is not typical kindergarten behavior. This child should be heard for a individualized education like for a child study. I would think they would be like, okay, this child's behavior, like let's look at, did they attend preschool? So kindergarten is not required in the state of Virginia. Kindergarten parents are only legally required to send their kids to school at the age of 6. So for first grade, but kindergarten is not legally required in Virginia. And then Lisa also said, I saw a psychiatrist on court TV say that his behavior. So I don't like it when our colleague likely lives in an environment that has high stress, conflict, because when you start labeling a 6-year-old a psychopath, you're not leaving room for intervention. And so a trauma and attachment informed approach would try to get this child in a safe environment. And so yeah, this is not just typical ADHD. I do think there have been allegations that the child was exposed to things in the home. So I saw in the chat somebody mentioned potential like DV exposure. Like there is more to this than just what we're seeing and hearing. But all of that was like, that's the state, and all of those things get investigated. So then all of that happened January 6th of 2023. And okay. So security resource officer is what SRO stands for. And that's typically an armed police officer in the state of Virginia. And so on January 6, 2023, instead of one SRO being shared between 2 schools. Okay. Yeah. So this sentence is worded weird. So I guess typically one school resource officer is shared between 2 schools, one of them being Richneck Elementary School. They're in the morning at one location and at another location in the afternoon. If there was an emergency and the SRO was not present, it is known that the teachers call the non-emergency police number or the surrounding SRO who was at another location. However, that SRO did not have a work phone. What? And there was not a number posted anywhere in the school that would inform any faculty what number to call. That's a problem. Second, the front door system was set up. Who wanted to gain entry to the school would call the main office to be let into the building. However, the system was broken for weeks prior to September 6, 2023. If a parent came to pick up their child, they had to knock or pound on the door to get someone's attention or wait until somebody passed by to open the door to let them in. The school doors, they are locked and you have to buzz yourself, like you have to press a button and the staff are alerted that you're out there, and then they buzz you to let you in. Yes, that system was broken. And then lockdown drills are required to be conducted by school administration. However, according to the Newport News Public School records kept by the by a program called Raptor, there was no records from Richneck indicating that the required drills had been conducted for the 2022-2023 school year as of January 6, 2023. That is wow. So in our child's school, I think they have down um they do a few drills in the first month of school. In the first month of school, they have lockdown drills. So a lot of people are like, they are asking, why isn't Abby suing the school district? And it's my understanding that that has to be handled through workers' comp. I agree with people's frustrations that a slip and fall should be workers' comp, but like a teacher being pew-pewed, like that should, especially if there were reports for hours that there was a weapon in the school and the admin did not do anything. But yeah, so it has to go through workers' comp first. So that's where we are. I did want to play a little bit of the expert from Abby Zwerner had a school safety expert. She did a phenomenal job because we are going to listen to the defense expert today. And that is going to make a lot of us want to pull our hair out. Some people might agree. I don't know, like small, but I think most of us are going to be like, what? What do you mean? How could you be blaming like the amazing teachers that put their own lives, oh, like, I don't know how somebody could try to blame any of the other teachers for this incident, but yeah. And it is sad that we think about that it is possible that elementary schools may start to have metal detectors. We've had a few incidents in the state of Virginia where a serious weapon has been found in a child's book bag, even elementary school. Um, and so these incidents are rare. So I don't say these things to scare anyone. And if people do own a firearm, you want to make sure that you keep it locked, you keep it in a lockbox. And you definitely do not want a 6-year-old to be able to have access to a weapon. You really don't want any child to have access to it because a child could have a really bad day, and if they see the pew pew, they could like do something. So like the incidents of children harming themselves, it significantly goes up if they have access to a weapon. And so those are some of those statistics. All right. So let me share my screen so we can watch the first expert that what she says is going to make a lot of sense. And then we are going to watch the defense experts and talk about it. Please let me know if y'all have any questions as we're going along. I have her at a not so great pause. I apologize. I'm going to press play in just a moment. All right. And we're going to speed it up to about 1.5. We're going to speed it up just a little bit. I'll slow down if I need to. All right, let's go.
That was revealed.
Okay, I think that might be a little bit too fast. 1.25. Let's try that one.
Open-ended questions. Well,
Yes.
Technically, they are leading, so I'll sustain.
Yes, Your Honor. What findings and observations did you come to as a review of your materials related to the first incidents of information conveyed to Dr. Parker?
My findings were that Dr. Parker did not take action that I think an assistant principal should have taken at that time.
Give me one moment. I did not turn off my Wi-Fi. Sorry about that. I got kicked off. Internet problems. I'm going to try this one more time. It was a little blurry on my end. All right. And maybe it's just the court feed. I'm not sure. All right. Let me know if y'all have any trouble hearing it. Okay. Yeah. Yep. Connection issue. I am back. So let's keep going. I'll back it up just a little bit.
My findings were that Dr. Parker did not take action that I think an assistant principal should have taken at that time.
And when you say should have taken at that time, tell us, in your opinion and in your experience, what actions we're talking about.
When an administrator receives a report of a suspected weapon, I was trained, and it's written out in most policies and procedures handbooks, that administrator is to take it as a credible threat until you assess the situation and find otherwise. And so when a teacher came and reported that student said that a student had a gun, and it was a student who an hour earlier there had been reports that he was having difficulty and was threatening students at lunch, action should have been taken at that time.
And do you have an opinion as to whether that action, lack of action?
I think I'm having connection issues today. No fun.
In your review of the materials, did it stop there? In other words, was that the last time that there was interaction with Dr. Parker about a weapon on campus?
From my reading of reports throughout the day, depositions and timelines and different things, it
Keeps going in and out. I'm trying to close things in the background to hopefully make this run a little bit better.
one more opportunity.
Sorry, y'all. We are having technology issues today.
Moment, right? And there's been evidence, so we don't need to get into what that is particularly. But that second moment, you say there's 4. What's your view as an administrator in that context, in Dr. Parker's situation, in terms of getting a second notice of a firearm on campus?
Hearing it the first time and not taking action, I don't know, what individuals were thinking at that time, but when it comes back up again, check the book bag, it's not there, but I'm getting reports that he has something in his pockets. That to me is a huge red flag. Take action. Get the kid secured, search, call law enforcement, alert the principal. There are many things that needed to be done, and none of those were done at that time.
And Dr. Schuffelbarger, I mean, we're talking about Dr. Parker's actions, but none of the other teachers.
For anyone that missed this testimony, I forgot to mention that she is a retired, she retired from, I think, the Virginia Beach School District. So Hampton, Virginia is part of the 7 cities. So Tidewater, 757, Virginia, there's an area of Virginia, southeastern Virginia, where you cross a bridge and you're in Virginia Beach, Norfolk, Portsmouth, Suffolk. And on the other side of the bridge, you have Newport News, Hampton, Williamsburg. You have all of these other cities. And so that's that area. I grew up down there from about 10th grade on, and I went to graduate school in Virginia Beach. So I'm just sharing that. All right, let's keep it going.
Called 911.
There's a chain of command in a school, and there are usually policies and procedures that guide that.
Yeah.
Teachers are taught, report to an administrator. Administrators are the leaders and are trained to take care of that. And it's my understanding that teachers did report it. Several teachers did talk to her about that. And, there's even a handbook provided by Richneck. Can I mention that? The staff handbook for Richneck Elementary.
We've talked. We can hear the objection.
Your Honor, that's the exhibit that was provided today and outside court discovery.
And that is a continuing objection.
Yes, my understanding the court's not ruled on that.
I thought we were going to go ahead and allow her now that the foundation's been set, or did I misunderstand what you thought we were going to do?
I think maybe I misunderstand what we were going to do on that, because that has not been discussed.
This is exhibit.
And it's also beyond the scope.
These are talking objections, so I'm going to fast forward through this
Or
way.
does it?
Of that.
Your Honor, I think I can cure concerns and streamline some efficiency.
So you're going to withdraw the question?
I'm not going to withdraw the question
Right.
because she hasn't really. I invited the objection preemptively because I saw Ms. Douglas, out of the peripheral, and so I don't think that there's actually objectionable testimony that's been provided thus far. I would just ask.
She's actually asked you a question.
That's right, and so I'd like to just continue the questioning in the event that we are going anywhere that council doesn't think we ought to go. We can of course take it up, but this is Exhibit 108, I think in particular, that we're talking about, that Your Honor permitted questioning as it relates to Mr. Sims yesterday, and so it has been taken up by the court. But ultimately, I think we can roll through this and get through it.
So the answer to your question at this point is no.
Okay.
All right, go ahead.
All right. So, Dr. Shufflebarger, in review of the materials that you've been provided, are there different hats that people wear in the world of administrating school and education system?
Yes, definitely.
And the hat of the assistant principal, the administrator responsible for a crisis management plan, you following?
Correct.
Was that the hat that, in your review of the materials, that Dr. Parker was wearing?
Yes.
And in your review of the materials, when that person wearing that hat has received the second notice of information as it relates to a firearm on campus, what's your opinion as to how, if at all, she responded or what her actions amounted to at that time?
From the things that I read, no action was taken. There was discussion about him putting it in his pockets and the size of the pockets, but no action was taken.
And from your perspective and in your expert opinion as a former administrator wearing that hat, what's your view and observation of what that amounts to? That's
failure to act in the course of safety for the school. That's endangers folks. When you hear something like that, I know I said it before, you're expected to take it credibly. Here's a second report that people think the student has a gun. Action needed to be taken to prevent possible.
And the only reason why I'm playing this testimony is because there is another expert that was brought on by the defense that is going to have a different view. And okay. All right. So here is Dr. Hagan. He is a forensic psychologist in Virginia. So the Abby Zwerner, she met with a forensic psychiatrist. He met with her for 4 hours for the first evaluation and then 2 hours for the second evaluation. In my last video that I believe I have down in the description, I did go through some of his testimony. I thought he came across very credible. He actually met with Abby. The defense is with that expert, they brought up the fact that he did not review her counseling records. They really harped on that there was something in the counseling records that may have changed or impacted his final conclusion that she has PTSD, and that PTSD is a direct result of the incident, and that prior to that date, she did not meet criteria for post-traumatic stress disorder. The defense tried to kind of allude to the fact that maybe Abby losing her father was kind of a traumatic experience at a period of time, because I think they're trying to reduce damages. So if Dr. Parker is found liable, her team is trying to reduce the amount of damages. And so I wanted to play a little bit of his testimony. He did not meet with Abby. So he reviewed all of the records. He's going to say, I think he's testified 477 times. He's been a licensed psychologist in the state of Virginia and Georgia since 1982. That was the year I was born, depending on like the month. For 43 years, he's been a licensed psychologist. He's a forensic psychologist. And so specifically understanding how the law interplays with things. And he was really brought in just to say that the expert should disclose if there's information that they did not receive that could impact their decision. I personally feel that Dr. Watson did a phenomenal interview. He looked at all the records. I don't think if he had looked at those counseling records, I don't think that it would have changed his opinion. That's just how I feel. But let's go ahead and listen to his testimony. So this is on direct examination by the defense.
Information you considered of a type you usually relied on for the purpose.
I'm going to turn closed captions on, and then we're going to start at normal speed and see if I need to speed it up.
For which you were hired.
It is.
And are there any issues about which you will not be offering opinions?
Several. I'm giving no opinions whatsoever on liability. I'm giving no opinions about anyone that I haven't personally evaluated. And I'm not going to get out of my lane and reach into the job of the jury with any ultimate opinions.
As a result of the information you considered, did you form opinions?
I did.
And are the opinions you formed held to a reasonable degree of psychological certainty?
They are.
Dr. Hagan, when assessing
So I did want to mention that the defense could have paid to have their own expert evaluate Abby, but that could have backfired if they hired somebody, paid for the evaluation, and that person determined, yes, this incident is the direct result. Yes, now she never had trouble being in places. She did not have the personality change. All of those things happened after that incident. So their expert likely would have came to, in my thoughts, would have likely come to a very similar conclusion as Dr. Watson. So what they did instead was they paid for an expert to challenge, maybe, I don't know, like it's weird because it's almost like challenging the methods Dr. Watson used, but I personally think Dr. Watson did a phenomenal job. So, okay. But
whether the forensic practice standards apply, what standards apply to a mental health professional when offering a diagnostic opinion in court? Tell us about the forensic standards that apply both to a psychologist and a psychiatrist.
One of the sources of standards comes from the American Academy of Psychiatry and Law. And that standard says that a mental health professional's...
Objection, hearsay.
You have a response?
He can state the basis for his opinion, Your Honor. That's clear in the case law. Otherwise, inadmissible hearsay forming the base of an expert opinion may be admissible for a purpose other than...
Personally.
So that standard from the American Academy of Psychiatry and Law says that a mental health professional's objectivity is enhanced when the professional considers all of the sources of information available.
so once again, the defense is harping on the fact that he didn't review every counseling note. And that would have been that would have been a lot of because if she's attended weekly therapy starting, or I don't know, maybe every other week, or if she's had therapy since 20, because she maybe some in college, definitely with the loss of her father in 2020, like that would just be a lot of records. And so he did thoroughly review all of the medical records. It is true he did not review the counseling records from Abundant Life, but a lot of the things are summarized in the psychiatrist updates. And so I don't know. But
when forming an opinion to be offered in court. That's one. Also, with which I am very well familiar, the American Psychological Association's Ethical Principles and Code of Conduct 9.01 says that when offering an opinion, if the evaluator is aware of certain information that he or she didn't develop or wasn't available but could be relevant and helpful, then they have a responsibility to tell their audience in their report or through their testimony what information wasn't available and how the absence of that information could negatively impact the conclusions they ultimately drew.
And that's only if that information would impact those conclusions. And so Dr. Watson testified that information would not likely change his final conclusion.
And Dr. Hagan, as a result of everything you reviewed, what opinion did you reach about whether the forensic assessment standards were applicable to a mental health professional's assessment?
I offer the following opinion to a reasonable degree of psychological certainty. Those standards which I just cited are applicable when a mental health professional offers opinions having assessed a person for the purpose of litigation, that is, for going to court.
And what is the responsibility of a mental health professional when offering an assessment of a person in court for litigation purposes?
To explore all of the sources of information that could be relevant and helpful, and to identify those sources that could.
Now, he could have looked at all those records, and he just would have charged them. Wow. I don't know. Like they're harping on this, and I personally don't think it would make a difference with his decision and his ultimate findings. I think it would have been a waste. I personally feel like it might have been a waste of money, but it could have made his opinion sound stronger if he had. But the fact that he didn't, I don't think there's anything in there that would change his opinion. Counseling records, counseling notes are just very personal.
Could have been useful but weren't available or weren't available at the time, and to state what impact the absence of that information could have on their ultimate opinion.
And does that relate to issues about the amount of the source of information that the mental health professional has?
It does.
Okay. And what about reliance on self-report versus other information?
Well, self-report means when the person who's being evaluated comes in and tells the evaluator information. A good starting point. But it's not the end point. It's important for an evaluator to consider all of the information, including information that may not line up exactly with what the person said. Just like in court, under direct exam, you're not just going to hear my answers to these questions. There'll be cross-exam, so the jury can figure out what weight to give what I have to say. That's analogous to when an assessment is done. You would ask the person, how are you doing?
Dr. Watson did look at a lot of other collateral information. The only thing he didn't review was so he didn't look at her getting her cosmetology license, because even though she has her cosmetology license, it takes her a significantly longer amount of time. She's likely not going to have a career as a full-time hairdresser because of the physical limitations that she has with her physical injuries. That's my understanding. She's likely, and to me, and Dr. Watson even mentioned it, so she could have just stayed home and done nothing. But she tried. She wanted to try to have some sense of normal. She wanted to try to do something, and I see that as a positive thing. And the defense, because if she had sat home and done nothing, I think the defense would have been like, well, she's just, I don't know. I feel like that would have been a problem too. But the defense is just doing what the defense does. Okay, they're just doing what they do. So yeah, I'm gonna let him keep going. Okay. Yeah, so we're almost to cross-examination.
How are you feeling? What's going on? What seems to be the problem? But when it's done with reasonable foreknowledge, that is, you know in advance that this is going to be used to assist a judge or jury in determining a legal fact, then there is a responsibility to develop collateral informants and to review records so that you have the full movie of the person's life rather than a snapshot at a moment in time.
Does the mental health professional rely on any psychological testing?
So a forensic psychiatrist does not have to do psychological testing. So often forensic psychologists will. So when you look back to the Amber Heard trial, Dr. Curry did do psychological testing. She is a psychologist. Psychologists often use testing just as another thing. Forensic, he did a 4-hour. I've never done a 4-hour just talking with somebody. It was likely a detailed, he was probably going through a lot of things. I have never done a 4-hour just talking assessment.
It's outside the designation. I don't know what we're talking about.
All right. What is, do you have a response?
I'm sure it's in his designation. Do you want me to?
But Dr. Watson was a forensic psychiatrist. He's not a forensic psychologist. I think Dr. Y'all know her name, from the Letitia Stout. I don't think she did tests. She did try a few like neurological tests or something. It was a very odd case.
Things we can talk about.
Sustained. Go ahead.
Does the mental health professional consider the person's adjustment prior to the index event for which they have been engaged?
Yes, the mental health professional doesn't cherry pick the information.
Jeff, the question isn't, does this person do this or that? This person's been proffered to testify as to what a mental professional ought to do or should do.
You can tell he's getting a little frustrated, but it's okay. It is what it is. But you should be prepared. Like, this is just, if you testify, this is what happens. They're going to argue about whatever you're saying. Especially the side that you weren't called for is going to object to something that you say. You just take a breath.
And the framing of the question is, do they do this? Do they do that? Do they do this? Isn't appropriately frame the issue within the context of what he's been proffered to testify to.
You have a response?
I can rephrase the question. Should a mental health professional consider records and information prior to the index event?
Yes.
And where would one gain that type of information?
Well, from what the person tells them and what they read from other sources. They need to have an appreciation of the context of why are they even getting this referral? What's the question to the evaluator?
Does the mental health, or would a mental health professional consider functioning prior based on collateral interviews and such?
Absolutely.
And Dr. Hagan, what is the mental health professional's responsibility if they don't do all the things that you just said?
They have a responsibility to their audience to say,
So he's just going to say the same thing again, that they have to say that they didn't do it. Okay, so let's go ahead and get to cross-examination. So we were almost there, 153.07. Okay, let's get to cross.
This is a,
Is roadmap?
Yes, we're not doing a roadmap.
We're going to every witness.
You can do a roadmap with your witnesses, but not with mine.
All right, I'm going to sustain the objection. Going to give them a roadmap.
Dr. Hagan, you ever heard of the phrase armchair expert?
yes,
Okay. And you testified earlier that a job of a forensic psychologist is to, I think it was, assess the intersection of human behavior with legal questions. Is that right?
that's the definition of forensic psychology.
So that's a yes?
It's not a yes. I'm clarifying that that is the definition of forensic psychology. It doesn't dictate what a forensic mental health professional does in each case. It needs to be driven, the conduct in each case needs to be driven by the standards that apply and the facts specific to the case.
And that's your opinion because you, in fact, didn't address the intersection of human behavior and legal questions in this case because you didn't evaluate Ms. Zwerner. True?
False.
You evaluated Ms. Zwerner?
No.
That's all I need to know. You did not evaluate Ms. Zwerner, correct?
I have not.
And so when you said you performed 1,000 psychological assessments, all 1,000 of those are people who are not in this courtroom. True?
That's true.
And you said that you testified, hundreds and hundreds of times. You testify almost every week.
No.
You testify a lot.
477 times.
So the Abby's lawyer is trying to say, like, he's like just reinforcing the fact that he testifies a lot. Okay, we'll keep it going.
Did you testify last week?
Not last week.
Soon, recently.
In October.
Okay. And when you were asked what you would be opining on, you agreed that you wouldn't be offering an opinion on liability, correct?
True.
And in your experience in forensic psychology, that's a, quote, legal question, correct?
Well, it's outside of my area of expertise, the liability question is. So I'm going to stay in my lane.
All right, let's stay in the lane then. And that lane in other circumstances included actually providing an evaluation of somebody at issue, true?
I have done that, yes.
And you understand that the court can order that you provide an evaluation of somebody if it's requested?
The court can order it, yes.
And that defense counsel, if they wished, could ask you to perform an evaluation? True?
Objection, Your Honor. First, it's leaving. It's not relevant. That's not an issue before the court.
All right, well, it's cross-examination. I'll allow him to leave, but what about relevance? You have a response to that?
Yes, Your Honor. The assessment is he's been offered to testify as to what a forensic psychology is helpful to do. And in this case, we're trying to figure out what he did, what he didn't do, so that the jury can understand how best to use or to evaluate his opinions.
Your Honor, Dr. Hagan has no input on defense counsel's decisions with respect to whether there would be an evaluation. He was very clear that he said he did not personally evaluate her and didn't need to offer his opinions.
He has his, and it comes across in like a Southern polite way, but there's definitely shade there. Like, it's not rude or like out there obnoxious, but it's he has some shade. He's throwing it in there. I appreciate his style.
Can you ask your question again, Mr.
Sure.
Neal?
Were you asked to evaluate Ms. Zwerner?
No,
Overrule the objection. Go ahead.
Did you ask to evaluate Ms. Zwerner?
no,
You understood that a question that this jury would be asked to decide is damages, correct?
yes,
You understood that a question that this jury would be asked to decide is causation, correct?
yes,
Is letting it sit there. Remember, I have it sped up a little bit. This is a long pause.
And you explicitly within your report stated, give me a moment here, that you will give no opinions about persons whom you have not evaluated, true?
true,
So you're not opining as to any, you did not offer any opinions as to her mental health diagnoses, true? You did not offer it in your report, true?
I'm not giving any opinions about her diagnosis. I have opinions about how the diagnosis was reached, the methods and procedures, giving no opinions about the plaintiff herself.
So I personally feel that anybody that met with Abby Zwerner would diagnose her with PTSD in a matter. I would only need like to know the details and then to maybe meet with her for 10, 15. Now we would meet for an hour, like we would meet for the entire time, but you can easily diagnose her with PTSD. There are multiple times during the trial where you can tell that she's kind of checked out. And there's a checked out that's very clearly PTSD versus just like bored, just kind of dazed off. Like there were times that you could tell that she was doing her best to regulate her emotions. Her sister's testimony was I think it brought up a lot of emotions for both her and her sister. I didn't watch all of her mother's testimony, but because y'all know I have a full-time job, so I'm not always able to watch every aspect, but this has just been very, very powerful thing. So this is a defense expert, and he's just being brought in to try to challenge the methods that Dr. Watson used. The defense wants the jury to know, or like to have in the back of the jury's mind, that maybe there was other information that like Dr. Watson didn't have, but I personally think Dr. Watson did a phenomenal job. I just think he did a great job. Dr. Watson was the forensic psychiatrist that met with Abby for 6 hours, 4 hours for the initial assessment, and then 6 hours. I think it was July. It was earlier this year.
So to answer my question, the answer is yes, correct?
The answer is the one that I just gave.
Okay. And so when we're addressing this specific issue in this case regarding post-traumatic stress disorder, you did not render any opinions regarding post-traumatic stress disorder, correct?
I rendered opinions about how that assessment was done. I'm not giving any opinions on the truth or the validity of the opinions.
That's because you didn't want to get your hands dirty and
It's
actually
because I'm
address it.
staying within my lane and not offering any opinions about anyone that I didn't evaluate myself.
Because that would violate its own ethical rule. True?
Yes.
I think that is true.
There's a Goldwater rule that says you shouldn't be offering opinions about people who you haven't assessed personally. True?
I'm not familiar with it under the Goldwater, but I know under American Psychological Association.
I think we heard about Goldwater during the Amber Heard trial again. So I've heard about these things because I watch trials. So I think that came up with the other Virginia psychologist who tried to who gave opinions about Johnny Depp's personality without having assessed him. And okay. That was brought up during that trial.
Association's Ethical Principles and Code of Conduct, published in 2016, section 9.01 through 9.03. It says you shouldn't do that, and I'm not doing it.
Thank you. No further questions.
Any redirect based on that cross?
Just a little follow-up.
You were asked about whether you needed to evaluate Ms. Werner to offer your opinions today,
I was asked that.
and you addressed that when you spoke to the jury the first time and said you did not need to do that.
I'm gonna come back to this because Lisa asked a great question. Couldn't that 4 hours of psychological? So it was an interview. So it was talking with her about her life before the incident, talking about the incident, and her life since the incident. It's a very thorough evaluation. They probably took breaks. So I'm guessing they took bathroom breaks. I'm guessing she could have water. So my evaluation, if I do the intake and assessment all in one day, but I'm doing psychological testing, which is testing somebody's cognitive, their personality, trauma symptoms, mood symptoms. I'm assessing all of those things. That assessment all in one day can take between 3 and 4 hours, a 3 to 4 hour interview. So this is also her chance to say what she's experienced and what's happened and how what's happened has impacted her. Yes, it can be triggering, but you need that information to move forward. And sometimes it might take longer because you might need to give the person more breaks. Or now sometimes those breaks, I don't know if that's included in the assessment time, because some people will stop the clock for breaks. Some people keep that clock going for like a 5-minute break, a 10-minute break. But Dr. Spiegel, thank you, Curiously. Yes, that was a mess. So that was the Amber Heard Johnny Depp civil case. I think that was the first time I talked about a court case on YouTube. And I didn't know how to use StreamYard, so I didn't know how to like react to testimony. And I might have to do that as like I don't know. I might have to revisit that one day. Yes. Hey, Mama. Welcome. All right. Let's keep this going.
First time, and second time, and third time. Yes, ma'am.
Thank you, Dr. Hayden.
May he be excused?
Yes.
All right. You are excused from your subpoena. Please don't discuss this case. All right. Thank you. You may leave the courtroom. All right. Next witness.
Next.
All right. So I'm going to skip ahead because then the defense called a school expert, 32923. So prepare yourself to maybe be a little upset, okay? We breathe through it, okay? Okay. I appreciate y'all's support. So this individual she's a school safety expert, and I'm not going to go like JD explains, if you want to see a lawyer, like he had some pretty strong thoughts about this witness and the last witness. Okay. Go watch JD explains video. They're only like 20 minutes. He does a really great wrap up. I will be a little kinder, but if y'all know me well, you know I'm leaving things out between the lines and you can probably fill it in. But this expert is going to say that the individuals at fault are the victim Miss Kovac, miss another teacher, and she's going to say that the Mr. Rawls, to me, all of the other witnesses, like Miss Kovac was super likable, like she just seems so sweet. And Miss Kovac is the one that actually got the weapon from JT. She put her, because he could have, like, she got it from him. Miss Kovac did, after Abby was shot. Abby made sure that her class got to safety before she received medical help. Like, the fact that she's blaming them, I cannot. But, she's getting paid, I think it was $500 an hour. I think it was $500 an hour. I'm just mentioning that because it was brought up by the defense. Okay. Lisa, I can't with you. No. All right. And so let me go on ahead and just press play.
A term that's used sometimes.
Yes, and they're first line responders. They are the people that can see it, that are experiencing it, that can provide context, a really critical context of what was said, what was the demeanor, how was the person acting, what did other people say, what sort of actions are being taken. And so those first line people provide really important intelligence for an administrator to evaluate the credibility and the appropriate course of action for a response.
And does every school safety concern require an immediate aggressive response from a school administrator?
School safety concerns require an appropriate response from an administrator, in the sense that it does not necessarily have to be immediate, it does not necessarily have to be aggressive, and sometimes that can be counterproductive. So if you think about the feasibility of every time a person discloses something, that we go to the nth degree and we're going to immediately lock down, or we're going to immediately do some dramatic response, you would never have school. You would be clearing classrooms all day long. It would be impossible for a school to function. On the other hand, school administrators have a responsibility to balance those things, to be able to get intelligence and information and make informed decisions about what the most appropriate course of action. Because think of the nature of a school where everyone runs around totally in crisis all the time, because every threat is being treated exactly the same, and we're going to DEFCON 5 on every single threat. That's not safety. That is constant panic. And it also actually can make the school less safe because people become numb to it. You get into a boy who cried wolf situation where people are going, well, it's just another one of those. It's just another one of those. So the appropriate response, a measured, appropriate analysis of the information and the situation is really critical to keep people safe.
And Dr. Klinger, can you tell the jury?
But we're here because a child actually did have, and so it's the testimony is going to get worse. I apologize, but we have to watch it. Okay. We can't look away. It's the jury had to listen to it. They're going to have closing arguments tomorrow. And then we are going to talk about this case with Josh Ritter from Court Confidential. He is going to be on the channel on Saturday about 4 p.m. Eastern. Okay. So stay tuned for that notification.
The factors that an assistant principal must rely on to assess the potential severity of a reported student behavioral issue.
Well, in terms of looking at trying to establish or analyze the potential problem, plausibility is a big one. How plausible is it that this thing could be occurring? And that really factors into the age. I mean, in this particular case, if you're discussing a potential weapon or something of concern at high school or a middle school level, it is much more plausible that there is the potential there that a weapon could be present. When you're discussing the plausibility of a 6-year-old having access and ability to bring a weapon to school, clearly we know at that point it was unprecedented and certainly not as plausible as you would find. So clearly that's one issue. Specificity is another, of how specific is the threat? What exactly is being said? What exactly is being disclosed?
Two girls said that he had a pew-pew in his bag. Another student said they saw bullets and a pew-pew. Another student, somebody said they saw them put something in his pocket. Or the teacher, like when Miss Kovac asked if she could look in his bag, he seemed, he was like, no, nobody can look in my bag. Like he seemed, and she was like, it was different. He was balled up in a corner. His bag was right beside him. He was acting strange.
Words, what terms are being used. And then there's the context surrounding it. And again, threat assessment teaches us that we need to have the context of in what manner, under what situation, what were the circumstances. All of that kind of information is really critical. And an administrator cannot get that because they're not a mind reader. They are not clairvoyant. They cannot be everywhere. The way to get.
So don't they have to leave their office and ask the questions? I don't. And JD actually like looked up her website. Like JD, he was, because he really liked that first expert I showed. So the plaintiff's expert that talked about school safety. And if you hear the word, because even if it's a toy, you still need to get it off campus. And in the state of Virginia, a student can be expelled for bringing a toy pew pew to school. Everybody knows you can't. I teach my child he can't say gun and he can't say bomb. Those are two words you can't say at school. like and then you don't joke about harming people or anything. Like my son and I we have conversations like that. This was just what? And it's going to get worse, but we're going to keep going.
That is to get that information from the people that are seeing it, experiencing it, talking about it, and getting those reports and being able to aggregate that information so you can look at how specific is this, how plausible is it, what's the context, how credible, how severe. And all of those things have to be taken into account in order to be able to have an appropriate response.
And you talked about the assistant principal assisting with a lot. Is the assistant principal in this role triaging information?
Yeah, it's very important to be able to, because again, as I said, this doesn't occur in a vacuum. So because an administrator cannot do everything, they have to rely on the capacities and the skills and the professional judgment and the input and the context from other staff members and other people with which they work. So it's really trying to aggregate those things together because you cannot make a decision totally and completely by yourself.
In your review of the material, you've told the jury what you've reviewed. Were there any actions taken by Ms. Kovac indicating that there was not a significant level of concern on January 6th?
I think it's an improper opinion, Your Honor, not an issue in this case as it relates to Ms. Kovac, and for the reasons I stated previously.
Ask your question again.
In reviewing the material, were there any actions taken by Ms. Kovac indicating that there was not a significant level of concern?
I'm going to overrule that.
Go ahead.
Well, Ms. Kovac was present when Ms. Zwerner indicated initially about some defiant behavior. Ms. Kovac was told by some students that there was a concern about JT.
Don't say what anything Ms. Kovac was told, but or just what your understanding of what action she took based on what she.
Based on the review of the materials.
Sorry. So yeah, you can't tell us what other people said, just that you relied on that information.
So based on the review of the materials, information was given that there was a concern. Ms. Kovac did not go to Dr. Parker. She did not call a lockdown. She did not call security. She instead went to an
Teacher isn't going to call the principal. The AP calls. She's a reading specialist. What? Like this part, she kept communicating her concerns to Dr. Parker. Miss Kovac, if you hopeful, I don't know if anybody knows Miss Kovac did a phenomenal job. She did the best. So Mr. Rawls, all of the teachers and people involved, they all did their best. And the admin did not do what, in my just personal thoughts, what I think they should have done. She should have done. If there's a report, somebody saw a weapon on a student, you go and find those girls that say they saw something. You call the SRO, because if Miss Zwerner had tried to get the thing from JT would have become more aggressive towards her. He has a history of choking out a teacher. Did we? So that's why I started with his history. Okay. He has a history of kicking, spitting. He has of being physically aggressive, threatening to harm people. He has a significant behavioral history. his behaviors were to the point his mother was supposed to be with him at school. And I don't know. So I watched her interview, and uh, we'll see what comes out during the criminal trial, because I wonder what all will come out during that. But the criminal trial for Dr. Parker. So Dr. Parker is not going to testify in this case, because if she did get on the stand, she would plead the fifth, because she is facing criminal charges. I think she was charged, I think it was 8 counts of child neglect, it was for every bullet that was in the weapon. She was charged with 8 counts. Oh my gosh, this is just so much. I know. I try to warn y'all when it's gonna get worse. I have my stress ball that I'm over here. So this is Nido. I talked with y'all about like my stress balls that I like. But all right. So we're just gonna keep it going for a little bit longer. On cross-examination, she's still gonna hold true to her points, but I think the plaintiff's attorney got some good information in front of the jury.
Investigate and spoke with the student or interacted with the student. When the student did not reveal the book bag, did not allow for the book bag to be looked at, Ms. Kovac did not call a lockdown. She did not remove the book bag. She did not remove the student. She did not remove the other students. She stayed in the classroom, and after a lesson left the classroom then to report to Dr. Parker that the book bag had not been looked at. She went to lunch, the students went to recess, she came back during recess to look at the book bag. She did not.
So we already know what happened. It wasn't in the book bag, but somebody saw him put something in his pockets. We are going to jump ahead to cross-examination, because the plaintiff's attorney is really good. He does a really good job at getting to the issues. I have the full links to everything down there, and they did. So I skipped the part where she blamed Abby, but like she might say it in some of this part. I forget exactly what she says in some of this. It's a lot. It's a lot. And then Lisa said, based on how the assistant principal acted, I'm pretty sure that she would have reprimanded the teacher. So I think the assistant principal was possibly was thinking that people just couldn't control their classrooms, and it's just like, oh, like she didn't leave her chair. There's a report of a weapon. Like what? It's just it's tough. She is no longer a school official. I'm just gonna press play. So this is the cross-examination by the plaintiff's attorney. Okay.
So in the materials that you were provided, Dr. Klinger, this is the sentence I was reading to you. At around noon, Ms. Kovac came to my office and reported that the students were saying the student, JT, had a gun in his book bag. Do you see that? Mm-hmm. Is that a yes?
Yes.
And so you said earlier, you can't go around every classroom, knocking on every door, searching every bag. You recall that testimony?
Well, I was speaking in terms, your question was about finding out if everything was okay. It wasn't about searching bags.
Okay, cool. In this case, there was a specific child reported to have had a gun in his book bag, true?
Yes.
And because communication is a two-way street and getting in good information is a two-way street, you would expect the assistant principal to attempt to get some information herself, true?
Well, according to that statement and the materials that I read, there was a discussion between Ms. Kovac, who was a seasoned educator with a relationship with the student, third in line in the chain of command. There was a discussion between her and Dr. Parker, and Ms. Kovac indicated she was going to go and look in the book bag.
And based upon the information that you received, that she checked the book bag, there was nothing in the book bag, but that there was a report that there was something put in his pocket, true?
That was a report made later, yes.
And you're familiar that in response, Dr. Parker observed that the child's pockets were too little, true?
That's in the materials that's alleged.
And so when we're talking about getting good information, to make sure that we're on the same page regarding good information, when we talk about Miss West and Miss West bringing a child to Dr. Parker, you recall your previous testimony about that?
She brought him to the office, yes.
In fact, according to Dr. Parker left her office and went and retrieved the child, true?
Which child are we speaking of?
The one that was eloping.
Yes.
So Dr. Parker at some point in time did decide, I'm going to leave my chair and I'm going to go deal with a student.
Yes. I believe she also left her chair when the students had the altercation in the hallway, and also to talk with Ms. West about the student she brought in from the playground.
And during those times in which Dr. Parker left her chair, did she go and inquire with the student JT?
Specifically to the student,
Yes.
JT, or about the student?
To the student JT?
No.
And you mentioned about how when law enforcement gets phone calls on dispatch, they always want to get information straight from the source. Do you recall that? Mm-hmm. Yes?
Yes.
And when we talk about getting information straight from the source, in this context, there were two girls who reported to Ms. Kovac who reported to Dr. Parker, true?
Yes.
And at what point in the day did Dr. Parker leave her desk to go talk to girl number one?
Well, in her testimony, Ms. Kovac indicates she didn't know who they were.
Not my question. At what point in the day did Dr. Parker leave her desk to go talk to girl number one?
How could she if she doesn't know who girl number one is? Because Ms. Kovac doesn't know who girl number one is because she didn't ask her name and didn't get the information, which makes it difficult to investigate.
So
If you don't know who the student is.
So Dr. Parker's obligation there stops because she doesn't get good information, so she can sit back and just rely upon the fact that she didn't get good information.
That's not what I said. I said it would be difficult to interview a student that you don't know who that student is.
You mentioned earlier that there are, 40 first grade students and 20 in Ms. Werner's class?
I never said how many students there were.
She didn't testify.
Earlier.
So, y'all, I mentioned that my child was he was on the playground, and a student he was cut with scissors on accident. I don't know. I think it was on purpose. He was cut with scissors. I think it was first grade. And we didn't find out until just after dismissal. And the next day, so that night we had an email from the assistant principal of what the plan of action was going to be the next day. Our child was brought to the classroom where we believe the student was. They tried to have our child pick out which student it was. He was not able to, but they still did something. So even though our child did not know could not remember which student cut him with the scissors, the school didn't just say oh, your kid doesn't know, so too bad. We don't have good information, so there's nothing we can do. No, the very next day, they took our son down. They tried to figure out, who it was. They talked. They made sure that, okay, when kids are at recess, they don't need to have scissors, basic thing. No. But they made sure to have those discussions and conversations. We talked with our child of hey, if something happens, immediately go and let somebody know. We understand. I think he wasn't feeling safe, and so that's why he waited until he was because they had a sub that day. If it had been his teacher, I think he would have let his teacher know. His class had a sub that day, and so I think that's why he didn't let the sub know. But to me, do something, and Dr. Parker didn't do anything at all.
Hold on, gotta sustain that objection. Rephrase.
Earlier, you had talked about how at some point in time, one of the teachers was looking after two classroom sets of students, true?
Correct. I said Ms. Werner had double the students. I didn't say a number.
Okay. And so just so we're on the same page, Dr. Parker never went and attempted to talk to a girl or two girls, true?
The ones that disclosed to Ms. Kovac you're speaking of?
Yes.
She did not because she didn't know their identity.
You said because she didn't know her identity. You've never spoken to Dr. Parker, have you?
No, I have not.
Okay, so when you're trying to say what Dr. Parker knew or didn't know, it's conjecture. You don't. She's never told you she didn't know the identity.
Well, the materials say that Ms. Kovac did not.
But
So I don't know how Dr. Parker would be able to know who Ms. Kovac spoke with if she didn't see her speaking with the two students and Mrs. Kovac didn't know the name of the two students. I don't know how Dr. Parker would know that, but you're right, I don't know that.
Okay, so you do not know whether Dr. Parker knew or did not know.
I do know that Ms. Kovac did not know the names of those students, and she didn't inquire or bring them to Dr. Parker so that Dr. Parker could speak to them.
Dr. Klinger, I know this is your first time in the courtroom. Just asking that you answer my questions. I'll be happy to let you expand, but I just want to make sure that we're not talking past each other.
Most certainly.
So, you do not know, because Dr. Parker never communicated to you, whether she knew or didn't know who those two girls were.
That is correct.
Okay. And when we go further and talk about getting good information, at some point in time when it's reported to Dr. Parker that there's a belief that there's something in his pocket, we talked about that a moment ago, correct?
Correct.
At that point in time, you'd agree that there's still at least a possibility that there's a firearm on campus, true?
Yes.
And at that point in time, to address the possibility of a firearm, did Dr. Parker request any specific information from anybody to be conveyed to her?
Specific information from anyone?
Correct. Did she say, will you go and search the person? Or will you go and talk to JT? Or why don't I go and talk to JT? Did she request any specific information in order to make the decision of what to do about a possible firearm on campus?
In the review of the materials, it would appear that that was a discussion that was had with Ms. Kovac and also with Mr. Rawls.
But that was, so let's get our timeline right.
To me, so Mr. Rawls asked, can I search the student? And Dr. Parker said no. Like, Miss Kovac said, I'll search his bag. Like, Dr. Parker didn't do anything. She didn't do anything. I like him. He's doing a great job, I think. We're going to keep it going.
Ms. Kovac looks at the book bag, no gun in the book bag. They go and talk. That's when the comment is about little pockets, right?
Yes.
And that's about 12:20 in the afternoon, true?
I don't have a timestamp on that, so I can't speak to that.
And then Mr. Rawls comes and talks to her at 1:40 in the afternoon. Isn't that correct?
Again, that's my understanding, but some of the times seem to be a little contradictory in my review of the materials. Some of the times, depending on the statements, were a little bit off, so I don't want to say 1:40 with certain.
Okay. So, Judy girl, I am so glad that Abby survived. So Abby Zwerner is a miracle. So the pew, the bullet went through her hand, and so there's still pieces of the bullet in her chest. It's in a place where they cannot get it out. For the rest of her life, she's going to have, it's physically in her. They were unable to remove the bullet from inside of her. Like, that alone is enough for me to, oh my gosh. She survived. And I think if she hadn't survived, I think those students would have a lot more trauma. And it's still a shocking incident. It's still a trauma incident. I'm sure students receive support. There's some students that probably didn't return to the school. The school was closed because this happened January of 2023. I'm almost positive Richneck, I don't think students returned for, it was a period of time. I don't remember exactly how long, but soon after they made decisions about admin. There were multiple things that happened. There were meetings that were held. If I was a teacher in that school, I would have some thoughts about safety. And so, yeah. Yeah. Let's just keep this going.
Let's say it was 1:40.
It was after recess.
Let's say it was 1:40. That would mean that for about an hour, Dr. Parker was aware that there was the possibility of a firearm on campus at Richneck Elementary. True.
That there was the possibility that JT had what students were characterizing as a weapon and a gun.
And did nothing.
Is that different than what I had asked you?
Yes, you said a firearm. Typically, students would not disclose a firearm. They would say a gun, meaning a squirt gun, a gun, meaning a Nerf gun, a gun, meaning bullets. Again, in my experience, students, I'm sure there are some, but very young elementary students don't typically use technical terms like firearms and things like that.
But we just looked at the report from Miss Parker herself, Dr. Parker, Exhibit 2, and it used the word gun.
Yes.
Okay.
I'm not disputing that.
And it didn't say toy gun. True?
The students said gun, yes.
And this report from Dr. Parker used the word gun, not toy gun. True?
That's what said the report says, yes.
Okay. And so, let's talk about the threat at that point. You mentioned earlier about this isn't something that would be foreseeable. Do you recall that?
Yes.
Your Honor, I'd like to, just for demonstrative purposes, it's just a scale.
Object, Your Honor.
I can't see what that is. Not exactly clear where you're going with that.
Object, Your Honor, it's another diagram.
Well, let's actually start before. January 6th in the morning, before JT comes to school. What, in your expert opinion on the issue of foreseeability, what was the foreseeability of a gun on campus at Richneck Elementary School, elementary school, on a scale of 0 to 10?
I would say 0.
Incorporating all students, K through 5?
Yes.
So every student there.
What was the foreseeability of a gun on campus? 0 to 10.
Inclusive of the entire population of the school.
Yes.
Probably a 1.
So it's not like it's off the radar. True?
Correct. Now,
And
if you want, well, I can't tell you what to ask me, but that's why I ask about the number of students. The younger they go, the younger they are, the lower that number would be.
Okay. But when we talk about a firearm on campus, we're talking about a risk, a threat. True?
Yes.
And that's because a firearm on campus at an elementary school isn't just a risk of an active shooter. You'd agree with that, right?
Yes.
There's a risk of an accidental shooting, correct?
Yes.
And so any firearm on campus is a threat. True?
Yes.
And so on a scale of 1 to 10 before January 6th, it's a 1. True?
Before January 6th?
Yeah.
I thought you said that
On the
morning.
morning of.
I thought.
That's what I mean.
Okay. Yes.
And
Overrule the objection. You're using this for demonstrative purposes only?
Yes, Judge.
All right, you may proceed.
go ahead, and you tell me if I'm misstating, okay? Say foreseeability
She gave it a 1.
of gun on campus. Is that right?
In a K-5 environment, correct? You're asking me?
Yes.
Yeah,
Is that correct?
that's correct.
And we agreed that this equals a threat, at least some threat.
The foreseeability
A gun
equals a
on
threat?
A gun on campus.
The gun equals a threat, yes.
Okay. And so we're at a 1. True?
Based on what you described to me, yes.
So we'll call it 9 a.m. 1/6/23. So you're familiar with the Richneck handbook, correct?
Yes.
And you're familiar that the Richneck handbook actually contemplates a level 3 incident involving the possession of a firearm, true?
Yes.
How does that change your determination of foreseeability? Does that make it more foreseeable because they've thought about it in the manual that it could happen, or does it make it less foreseeable?
I'm sorry, I don't mean to. I'm not sure that I understand what you're asking me.
Sure. In the context of Richneck Elementary specifically, there is a handbook that calls a Tier 3 threat assessment, and that is if there's a possession of a weapon. Do you recall that?
Yes, I believe that's for the whole district, though, not just specifically for Richneck. Is that correct? Your understanding as well?
And Your Honor, if he's going to question her, he can show it to her.
Happy to show it to her.
Show it, publish it to her. I'm not sure it's in evidence, but.
Evidence is
Okay, if it
Exhibit
is the
108.
one that is.
Exhibit 108. You see the Richneck Elementary School staff handbook?
Yes, I do.
And
Okay, so I'm going to go ahead and pause. If y'all would like to come on, like to look at the rest of that testimony, she's eventually going to get up that it's going to get to like a 3 out of 10, the possibility, but she's still going to say Dr. Parker had no responsibility to do anything and that the teachers could have done something. And I'm just like, oh my gosh, like that just blew my mind that somebody would get up and say that. This was her first time ever testifying in a court case, court testimony. So to be cross-examined, I am thankful that any of my past cross-examinations. So I'm glad that's not. So it was family court, and so though there were not cameras, those are not televised, and so. I didn't do bad on cross-examination. I have to do a lot to manage my face. And there was one attorney, I forget his name, but I had to testify in front of him 2 or 3 times, at least 2 or 3 times. And he just had a way of trying to get under people's skin on purpose. And he would just ask the most asinine questions. Like I was not personally a fan, but he did a good job for his clients. He really did. I was professional and I answered his questions, and along with all the other testimony, the judge normally ruled. So I was normally testifying on behalf of the state because it was normally a DSS case where they were looking to make a decision about children, and he was normally supporting, and I was just giving the information, but it was so much. It didn't get better. It didn't get any better. I am looking forward to watching the on replay. So when I was a baby therapist, I tried to control my reactions more. I now use my response to be therapeutic. So when clients meet with me, they are not getting a blank slate. So, but what I don't do, so if I have somebody that's sharing really horrific things, like they've had thing after thing, there's a lot that's happened. I will often take a breath with them and just reassure them. I'll thank them for being comfortable sharing it with me. I'll let them know that I'm able to hear it. I'm able to handle it. I've worked with very complex cases before and have heard almost everything. I will let people know, like, wait, like this situation, like this aspect of your story. So that's that. Yeah. Like that's, whew. But I will often connect with them, but it's in a professional way that I hear you. It's validating. It's safe, but I'm not having like no response. They're not talking to a wall. And then there are times where, so like if a client tells me they, they made a not so great decision, I would, and I have a really good relationship with them, I'll be like, or if I have a client that says they're fine, but they're really not fine. So I'll ask, so how are you? They're like, I'm fine. I'm like, how are you really? And then they'll tell me how they're really doing. Or I have some clients that want like it's really hard for them to be the focus. And so I really enjoy what I do. I love being here on YouTube because I can't help everybody. So I send a lot of people away, and I try to use cases like this to teach mental health principles. And from this case, I thought it was powerful that Abby Zwerner, the plaintiff in this case, she has received EMDR, eye movement desensitization reprocessing. I do have a link to EMDRIA. That's the International Association for EMDR. Little John actually recently went on the Breakfast Club and talked about how EMDR therapy was really helpful for him, and it helped unlock some subconscious things for him. And the way that he described it, that was a very similar experience I had receiving it because any therapist that does EMDR has to receive it during the training process. So we practice with each other as client, as therapist. And so I was able to get 4 free sessions of EMDR. When I go back to therapy, I will likely find an EMDR therapist. I think therapy for therapists is very important. I have a lot of other support. I have a lot of other things that I do to help manage and maintain mental health. And if there's ever a time where it's like, oh no, I need therapy now, I make sure to, because I've had about when I actually found the right person, I've had 2 instances in the past where it was like, ooh, girl, you need to talk to somebody. And I made sure to find a therapist, and I was able to work with some people. You all know my very first therapist was not the right fit. Fit for therapy is very important. But with EMDR, I found my relationship with the therapist didn't matter as much because my brain was doing the healing. Like it was very, it was very strange because during the training, there were a few people where it was like, I don't know if I have a great connection with them, but they did my EMDR. Like it was just as helpful no matter who was doing no matter who my clinician was, it was still helpful. And so I hope you all have a good rest of your day. Virginia, we have an election results that are going to start rolling in just like a minute because polls close at 7 p.m. And so later tonight, I'll be watching. I'm so glad to not hear the I am speaking. So I'm in Virginia, and I'm done with political ads. And so I'm so glad to not get any more text messages for like another year until like the next until new elections start. Your therapist does brain spotting. Nice. But you haven't tried it yet. Yeah. So the person that rents the office next door to me, she's considering either doing EMDR training or brain spotting. I have not done brain spotting, so I can't speak to that one. But I really had a good experience with EMDR. Make sure they are EMDRIA trained at least. I would at least look for somebody that's on that website, because there are people that say they do EMDR, but like they might have done a 4-hour PESI training. So the training I did was 40 hours. I did a 40-hour like intensive. It was I did a very, it included 10 hours of consultation. And then I'm going to continue on the path to get EMDR certified, to get my certification. Trained is fine. EMDR trained means that they went through the process and the 10 hours of consultation to be able to do EMDR. I appreciate you all. Thank you, Karen, for being the mod here today. Thank you to any other mods. I think my mom is a mod here too. And I so appreciate each and every one of you. I will see you all on Saturday with Josh Ritter. What? I'm super excited, from Courtroom Confidential. I will see y'all on Saturday at 4 p.m. Eastern. I hope y'all have a great evening.